electronically, and then if you have to file it under seal, then you'd have to follow the under seal procedures. And so in order for a lawsuit to initiate, there has to be some type of document that's filed with the court to start the process so that the court has jurisdiction. So it'll be a complaint, and the other thing you see, like in FL, is a petition. So the two instances where you'll see a proceeding initiated is in full-blown litigation where there's a complaint, or there's like a petition to arbitrate, or a petition to serve a third-party subpoena, or something like that. So you'll see either petition or a complaint, and those two things is what initiates the jurisdiction of the court. And then you have a case number and a judge assigned and all of that. Is there any questions about that first stage of litigation?
No.
Okay. So within that first stage of litigation, you'll generally see the following. You'll see, motions to dismiss, or you'll see answers, or you'll see counterclaims. You'll see motions to strike. Basically, once a complaint is filed, the other side has to respond to it. And that will be either in the form of an answer or a motion. And the typical motion would be a motion to dismiss, or a motion to strike, or a motion for a more definitive statement. But those usually are the things that you see. And the strict construction of a pleading is the complaint and the response. But most people use the term pleading broader than that to be anything with a caption that's filed with the court. So when we do our OneDrive and we do, saving documents and stuff, I don't distinguish between pleadings and motions because it just gets too confusing. But the real definition of a pleading is the complaint and the response. But and in the first stage of litigation, which is what I call the complaint stage, what you'll typically see, if you see an answer, then that's the end of the story. But if you file counterclaims, then the other side has to answer to your counterclaims. They could also move to dismiss, move to strike, move for a more definitive statement. If, as the defendant, you move to file a motion instead of answering, then after that's, sometimes in response, the other side will file an amended complaint, and then it starts all over again. So do you have any questions about that?
No, not at the moment.
Okay. So once you get, in that preliminary stage, once you get past the pleadings, which is the complaint and the response, you'll get the second stage is what I call the procedural stage. That's the stage where you're going to have a case management conference to meet with the judge. You're going to have to negotiate a schedule of the case. You're going to have to negotiate a protective order for discovery. You're going to have to negotiate an ESI stipulation for discovery. So you're in I call the procedural stage, which is the pleadings are settled, and now you're in the procedural stage to set the schedule for the case. So you'll get a case management conference statement that you have to prepare. You get, you have to, sometimes, will you agree to the magistrate or not? Who's the judge going to be assigned? You'll have to deal with some procedural issues like certificate of interested parties. You'll have to deal with, um, protective orders and ESI stipulations and preservation and stuff like that.
Okay.
So once you get past the case management conference stage and you get a schedule, then you're off to the races. Then you're in the discovery stage of the case. And there are four methods of written discovery. One is depositions. Two is interrogatories. Three is requests for admissions. And four are document requests. Generally, in the discovery stage, nothing gets filed except for motions to compel. And you slug it out in the discovery phase for about a year or more. Within that phase, you'll probably have another case management conference. And at that point, you don't do a CMC statement, you do a status report. Although I have filed them as CMC statements, but I've run into opposing counsel now who are like, it's not a CMC statement, it's a status report. Because they don't want to go through all the required things you have to do for a CMC statement, which is different from a status report. And so in the discovery phase, you'll see motion practice. And you'll have to serve written discovery. We'll have depositions taken. You'll have to arrange for court reporters. But you're in the slug of discovery. After discovery ends, so you go on to expert discovery and the expert phase of the case. So, any questions about discovery? The discovery phase?
No. That's the
Okay.
phase that I have that I feel like I'm the most comfortable with and like familiar with.
Oh, good. Okay.
Yeah.
So then, in the expert phase, it's twofold. It's you have to do expert reports, which do not get filed with the court. And you do expert discovery where you'll take a deposition. There might be some motion practice surrounding the expert reports or the depositions taken. But, motion practice should be fairly straightforward and minimal. So that's what the expert phase is. After the expert phase, you're in summary judgment and the pretrial phase. And that's when the filings increase. Oh, and so you could have motions for summary judgment. You could have motions for summary adjudication. You could have motions, and that's the MSJ phase. And then when you get to the pretrial phase, that's when it gets real. You will have motions in limine. You will have motions to strike experts. You will have to do deposition designations with the court. You will have to do your trial exhibits with the court. You will have to, I'm trying to think, you might have to file motions with the court, to allow technology people in or, but generally it's motions to strike, motions in limine, trial exhibits, deposition designations, jury instructions, things of that nature. And all of this gets filed. The Disney case that just happened, if you were to go look at that docket, gives you a pretty nice picture of all of the pretrial filings because their trial started in December, so all the pretrial filings were in November. And then, so any questions about the summary judgment pretrial phase of a case?
Not at the moment.
Okay. So then you go to trial. Oh, and by the way, the pretrial, you also do a trial brief. I forgot about that.
Oh, right.
You do a trial brief as well to explain to the judge what the issues are, what the evidence is, all of that. So then you get to trial. And trial, depending on the size of the case, our cases are relatively small to medium, is a week to 2 weeks. And, there could be motion practice during trial. So, for example, someone changes their expert report or their damages claim before they're supposed to take the stand. Motion for judgment after the plaintiff rests. There are trial briefs that get filed. Motion for a new trial after the jury renders a verdict. There are motions that are made specifically for trial. The judge may ask you to brief something. Maybe there's a new exhibit they want to introduce, and you file a motion to strike to say, no, they shouldn't be allowed to introduce this. And then the court asks you for briefing on it. Basically, there could be surprises where you have to brief some stuff. And trial is on a very, you have to do everything quickly. It's somewhat brutal, which is why having, one person in court and one person on the ground in the office to help with stuff is really, really helpful. And then after trial is over, there's post-verdict motions. And those are on a slower schedule. Motions for a new trial, motions to change verdict, notice of appeal, and then you're off into appeal land. And so to recap, the four stages of litigation is the pleading stage, which is the complaint and response. Then there's a procedural stage where you set the schedule and you get the administrative stuff out of the way. Then there's the discovery phase. Then there's the MSJ pretrial phase. And then there's the trial phase. And those are the 5 stages of a lawsuit. And then the 6th stage is post-judgment and appeal. The hell is my husband doing? I can't. And those are the stages. And so, for example, Ashley, and you can work on this with Jorge, and obviously if you have any questions, and I can do this again once the whiteboard comes in. But for example, case management conference statement, you should try to find that event.
Okay.
Status report, find that event. Motion for summary judgment or adjudication, find that event. Motion to compel or letter brief. And then another motion that you're going to see a lot is administrative motion for relief. And that's usually for extensions or for motions to seal. Another one that you might see is to change a hearing date or something, to alter a hearing date or the schedule in a case. If something's not by stipulation. And I think there's a search bar in ECF Pacer that I think if you... So I don't know, does someone want to log into Pacer and get to the event screen? And then I could be a little bit more specific and match up the phases of litigation with the events. Can you do that, Ashley?
Yeah.
Awesome. And then you're going to have to share your screen, though.
Oh, yeah. I'm just going to get to the page. Here we go. Share. Window. Yeah, window. Okay. Can you see the screen?
Yes.
Okay. Oh, that's didn't work. There it is.
Okay. So I guess from here, how would you log into a case? Okay, cool. Here we go.
I think it's a little delayed.
So you'll see right here, open a case, right?
Yeah. Open it. So open a case.
So that's where you would do what you need to do to do a complaint.
Oh, a complaint. Okay.
And you'll see here initial pleadings and service. It's complaints and other initiating documents, miscellaneous initiating documents, service of process, answers to complaints, other answers. Excuse me.
Oh,
Then they have motions and related filings. And we're not going to be doing pro se stuff here, so you don't have to worry about that.
Okay.
It's either going to be motions, stipulations, or other supporting documents. Then the other filings, as you can see, ADR documents is stuff having to do with mediation. Sometimes there's forms we have to fill out.
Okay.
And that's where ADR would happen. There's notices. I'm not sure what those notices would be. Trial documents we talked about, appeal documents we talked about, and then there's just an other. Attorney admissions we talked about, and then they have file in a sealed case. So that really has to do with if there's some government investigation and the entire proceeding is under seal.
Okay.
It's usually criminal or domestic abuse or something.
Oh.
It's very rarely civil.
Oh, okay.
So that's probably not something you're going to deal with. But why don't we start with pretending to file motions general. Let's look to see what they got there. So you should be familiar with the administrative motion to file under seal, correct?
Yeah. Well, just because we did it before.
Okay. And so do you know, so let me just explain, I find that if you understand the logic behind certain things,
yeah,
it might make it easier to, figure this out.
Yeah.
So the federal rules have something called you can do some administrative motions. And these really are administrative things. They're not things like motions to strike. They're not motions to dismiss. They're really procedural stuff.
Okay.
That's how you could think about it. I want to change a hearing date, or can I get more pages for my opposition, or can I change can I get an extension on something, right? They're really procedural things. And and motions for seal are, for whatever reason, are considered procedural. So you'll have two different types of administrative motions. One is strictly for filing things under seal, and that falls into two categories. That falls into us affirmatively filing our stuff under seal. But then, if we're filing another party's stuff under seal, we have to do an administrative motion to consider whether another party's material should be sealed. Okay. And then there's the third administrative motion, which is the other thing I talked about, which is I want to move a hearing date. I want more pages on my opposition. I want a case management conference moved because I'm on vacation. Those kinds of things.
Oh, okay.
Does that make sense?
Yeah, that makes sense.
So, most of this other stuff, if you scroll down, I don't think you're ever going to do.
Oh, okay.
So there are some here. My bad.
Discovery, yeah.
So you'll see, yeah. So you'll see there's judgment on the pleadings. There's I think there was motions to dismiss. There's judgment as a matter of law. That's, I believe, summary judgment. There's partial summary judgment. So I think you just have to get acquainted with some of this stuff. And, like, we're never going to do a writ of habeas corpus.
Okay.
A writ of mandamus is very rare. A writ of mandamus is when you, I actually don't think we would ever do that either. A writ of garnishment we're not going to do. We could do withdraw as attorney. But, like, what I would suggest that you do for, we might do a motion to transfer the case. For ones that you don't seem familiar to you, you can just do a Google search to better understand what they are.
Okay.
But if you scroll up a little, you'll see, like, I could tell you some other ones that we probably wouldn't use. But this is pretty comprehensive.
Okay.